Welcome to the Docketing Excellence Webinar Series.
Welcome to the Docketing Excellence Webinar Series, which is sponsored by Black Hills IP and the SLW Institute. Black Hills IP is an accurate, efficient, and cost-effective U.S.-based IP docketing and paralegal service provider. The SLW Institute is an educational group created by the Schwegman, Lundberg, Wissner firm, which aims to provide insightful and useful information to the IP community. For this webinar series, we have pulled together docketing experts and managers from the Schwegman firm, Black Hills IP, and their respective clients and customers to help educate on key docketing challenges and issues and share best practices on how to overcome them. The Docketing Excellence webinar series is free. To listen to our past webinars or to register for future webinars, go to the Docketing Excellence Series tab of the Black Hills IP website, which is www.blackhillsip.com. The webinar that we are presenting today is the first in a series of several webinars on trademark docketing. Today's topic is U.S. trademark docketing basics and beyond. We've allowed time for questions at the end of the webinar. Questions may be submitted using the question button on the right-hand side of your browser window. You can submit a question at any time during the presentation, but the question will be held in a queue until the end of the presentation for us to respond to it. Today's presenters are myself, Shelley Cape, and Patty Giuliano. I'm a patent attorney. My name is Ann McCracken. I'm the president of Black Hills IP, and I have 20 years experience as a patent attorney working in the patent prosecution area. I was a partner at the Schwegman firm for 10 years, and I was also a full-time law professor and directed the patent prosecution program at Franklin Pierce Law Center for 5 years, which is now the University of New Hampshire. Shelley, can you introduce yourself?
Yes, my name is Shelley Cape, and I am the Quality Control Manager at Black Hills IP. I have been in the IP field for a little over 40 years, the first 8 of those as a trademark secretary. The last 25 years I've been in some docketing capacity or another, and that has included a lot of trademark docketing along the way.
Well, thank you very much, Shelley. Patty, can you tell us about your background?
Yes, as Ann mentioned, my name's Patty, and I have been doing trademark paralegal. I've been a trademark paralegal for a little over 20 years. Prior to that, I did some corporate work and some other things. I recently moved to the Schwegman firm with my attorneys Pam Hoff and Christy Dent. The practice focuses solely on trademarks with an emphasis on international portfolio maintenance.
Great. Thank you so much, Shelley and Patty, for taking the time to prepare this program and talk to us today. Patty, I went one slide too far. Let me go back. I'm going to turn it over to you to kick this off and tell us about trademarks.
Okay. Well, today I'll be talking in very general and basic terms about trademarks and docketing of trademarks from a paralegal perspective. I've spent most of my trademark career using the PATSI database, and I'm now using FIP. I'm much more conversant on PATSI, obviously, but I think I'm coming up to speed on FIP. So what is a trademark? It is the word, name, phrase, or symbol used to identify the source or origin of a good or service provided through commerce. So first, generally speaking, the term trademark can be used to refer to both trademarks and service marks. But the term service mark can only be used in association with actual service marks. However, for docketing purposes, there is no difference between a trademark and a service mark. Looking at the slide, you can see that we have 3 logos and the items here. An example of a trademark would be like Herbal Essence, which mark is used in association with hair care products, and those are goods, so that would be a trademark. Other marks might function as a trademark and a service mark. For example, Starbucks has trademark protection for its beverages, but they also have protection for their various retail services. Likewise, Uber has protection for use in association with their goods and services. Conversely, patents protect the method Clairol uses for making their products or the algorithm Uber uses to connect their drivers with their passengers.
I just want to throw in there that Patty had indicated that there was no difference between a trademark and a service mark. This means that they're treated the same in the trademark office, regardless of what you or the applicant or your attorney call them. Whether it's a trademark or a service mark, it's processed and docketed exactly the same way.
That's correct.
Right. Shelley, I imagine that's probably kind of confusing for people when they're first starting to docket and they see those different names on things.
Especially for new trainees, and they see that, they think it must mean something totally different. It does not when it comes to the docketing process.
Great. Well, great point. Patty, I'll turn it back to you.
Okay. Well, unlike a patent, a trademark registration can be kept alive forever if you continue to use the mark and pay the fees along the way. Even if someone doesn't maintain their registration, they can still have rights to the mark if they continue their use. So if the trademark owner does not have a registration, or if they let their registration go, they still can rely on their common law rights. If one has a pending application, or if you're simply relying on your common law rights, the proper notation would be the trademark symbol, the TM symbol. Only registered marks can use the R in a circle.
Great. Ready to move on to the next slide?
Yes, please.
All right, here we go.
Okay, so when choosing a trademark, one should come up with something that conveys the image they're wanting to project. For example, the mark Mustang in use association with a car. To many, Mustang produces a fast and wild image that appeals to most purchasers of that particular vehicle. Also, the McDonald's trademark, I'm loving it, can produce a favorable mental connection that many people really love the food. So once a decision is made about which mark they like, a comprehensive clearance search should be conducted to be sure your mark isn't similar to other marks, particularly your competitors. And while doing so, you must consider not only the marks, but the goods and services protected under a mark. You don't want your customers easily confused when they are making their purchasing decisions. Also, you want something that is protectable. A trademark is not protectable if it simply describes the goods and or service. For example, very simply spoken, you cannot protect Apple for apples, but you can protect Apple for computers.
And one of the things to think about here is that Patty mentioned a comprehensive search that's done before a filing happens or a mark is decided on. Most applicants go through a lot of work before deciding on a mark so that it is strong and not similar to other marks that are out there. Basically because, when you consider the costs involved with branding and marketing a new mark, they really need to research before deciding on which marks to apply for.
Exactly.
Good points, both of you.
So on to filing and prosecution. Federal applications are filed with the USPTO. Electronic filing is recommended, and the filing fees are much cheaper, with fees ranging from $225 to $400 for an electronic filing to $600 for paper filings. The ultimate fees you pay are the same for all filers and are not based upon small or large entities like in the patent world. Among other things you need to know before you file, in addition to the applicant information, is things like whether the mark is already in use, which is known as a 2A application. If the client has a bona fide intent to use, which is a 2B, that they're going to use the mark in the near future. If the mark is in use, you'll need the date of first use before the general public, and you also need specimens of use. For non-trademark practitioners, a specimen is your proof of use. For example, a photo of the shampoo bottle we saw earlier showing the herbal essence, showing the trademarked herbal essence on the goods, or a menu board at Starbucks proving up their use in association with their retail coffee shop services. You can file an application based on an intent to use, even if the mark is already in use. And we sometimes do that if an acceptable specimen is not readily available when we're ready to file, because we may want a filing date as soon as possible. Things to remember when you're docketing it's important to ensure that you have a status check from the filing date, because you are responsible for maintaining the flow of the application and making sure that it doesn't get stalled along the way. And also, you'll want to make sure and docket the 6-month foreign filing priority date. Those foreign filings are outside the scope of this particular discussion, but you do need to be sure they're in the docket because the deadline runs from the filing date.
And as a docketer, when Patty had mentioned specimens and that you can file it as an intent to use or as a use-based case, when the first thing that a docketer will usually see is the email receipt from the trademark office confirming the filing of that mark. And the email receipt will include all the information a docketer needs to add it to their docketing system: the filing date, the serial number, the goods and services, the applicant, all of those things. And in order to tell, because most systems you need to designate is this a use case or an ITU, in order to tell on that filing receipt, you can look for either the dates of first use, which obviously if there's a date of first use, it means the mark is being used, or you can look for the indication that the application was filed under Rule 2B. If you see that 2B, then you know it's an intent to use application and there are no first use dates. I also want to throw in there that the foreign filing deadline is 6 months for a trademark from the filing date, not 1 year like patents.
Yeah, and I'm glad you mentioned that, Shelley, because my practice was in the patent area, and I didn't realize until recently that trademark docketing, your foreign filing deadline is different. So that's a great point for anybody who is transitioning from a patent docketing background to a trademark docketing background. That really critical date is a shortened time period than if it were
a
patent foreign filing deadline.
Mm-hmm. Yes.
Good.
So once an application is assigned to a trademark examiner, I'll back up just a little bit. You file your application, and it's usually from 3 to 6 months between the time you file and you get assigned to an examiner. Then once it's examined, it will either go directly to publication, which is not very often, but it does happen, or an office action will issue, and that is usually the case. Sometimes the issues are really minor and can be resolved by an examiner's amendment. In this situation, an attorney will call the examining attorney and either agree to, for example, minor amendments or possibly agree to enter a disclaimer or something minor that can be handled outside the written response. In this case, the examiner will issue an examiner's amendment based on that phone call, which will then cancel out the office action, and the application will proceed to publication. If a more substantial response is required and you need time to confer with your client and draft the arguments, we find it helpful to docket not only the 6-month deadline, but also 3 months out, 2 months out, and 1 month out, so the deadline doesn't sneak up on us. In some instances, an examiner will issue a priority action rather than a standard office action. In this case, you're given the full months to respond, but you don't have to take the full 6 months. If you do respond within 2 months, there is an implied agreement that the examiner will review the response quickly, and that should push the application toward registration faster. So that's definitely something you want to do if you have a use-based application and you're trying to push it to registration in a very fast manner. Just in case you end up taking up the full 6 months from a docketing perspective, you want to be sure that you've docketed not only the priority deadline, the 2-month priority deadline, but you'll want to also docket the 6-month deadline, again, keeping in mind that we like to use the 3-2-1 reminders to be sure that we stay on task with our response.
And I've seen situations where an examiner has issued one document called Examiner's Amendment / Priority Action. And that gets kind of confusing from a docketing perspective because an examiner's amendment doesn't have any due dates on it, but a priority action does. So the suggestion is as long as it's called a priority action in the title, you should docket those priority deadlines. And normally the trademark office is really good about putting that information in the document itself, so it will note that you've got 6 months from the mailing date. It just sometimes you look at it, you think examiner's amendment, I don't have to docket anything, but that could be, you need to look at it because it could be a little confusing.
Good. Well, Patty, tell us what happens then once a response is filed.
Well, like we said earlier, the response is due within 6 months, and unlike patents, typically no fees are required unless you're adding a class or if you filed on a T's plus basis, in which case there's certain things that if you have to enter a translation or if you have to list prior registrations that you didn't enter in your application, they may incur that extra filing fee at that point. But there's no fees for like filing within a time period. But once the response is filed, it is very important that you docket a status check. There are some docket systems out there that do not launch a status check off a response, and you'll need to go and do it manually. This is really important. We've had instances where a response was filed and then we didn't hear back. This doesn't happen as often anymore because everything's electronic, but kind of a funny story is we were waiting and didn't hear anything. We were getting close to our status check date, and I called, and our examiner had left the USPTO, and they told us who had taken over our file. Well, so I contacted that person, and he literally walked down the hall to the former examiner's office and saw a stack of files sitting in the corner that had not moved since the gentleman had left 3 or 4 months prior. And they would have probably sat there had we not called or someone called to inquire about the status. And it is your responsibility to make sure that we do keep the applications on track. So once you get your response filed and the examiner's reviewed it, and then you're successful in arguing your case, or if you're unsuccessful in arguing your case, a final office action could be issued. In that case, you have another 6 months to respond, but the response is called a request for reconsideration instead of a response, even though it's the same thing. It's the same format. On the USPTO website, it is filed in a different spot than the response, though. You'll also need to file the notice of appeal by the deadline. We often docket an early response deadline, roughly 3 months out. That way we can file our final round of arguments and enter any amendments that we might be interested in doing. That way, if the request for reconsideration is accepted, we don't have to file the notice of appeal, and the client doesn't have to pay those appeal fees.
And I want to throw in something here about those status checks because they are so important in the trademark process. Different docketing systems are configured differently, as Patty mentioned. Some systems automatically will launch a status check when a response date is completed. Other systems don't, and then the status check needs to be added manually. Most systems that I've worked with over the years have an option so you can set the system to respond however your organization would like to see it, automatic or manual. Also, when the status check comes up on the docket, don't just close it out or move it forward without talking to somebody, because it is so important in trademark practice that the applicant follows up on what's happening. You want to make sure that something was actually done before you move that status check up, or happen to close it out and then there's nothing on the date. So as you are looking at these status checks, just remember that they're very important in the trademark practice.
Very important, yes.
Great tips.
When you're filing your response, your arguments may include things like a defense against descriptiveness rejection. You may have third-party marks cited against you as prior pending or registered, or it could be something like an amendment to the description of goods and services. Another type of response we have been seeing more often is the request to divide out classes. You can divide out classes that are the subject of a rejection so that the other classes can proceed to registration. Like an example would be, you've got class 5 is rejected based on a prior pending application owned by a third party, and that application is suspended pending the disposition of yet another application. We have actually seen this happen where there's 3 or 4 different suspensions going into your suspension or your rejection, and you know it's going to be years before all of that is resolved. However, you might have other classes of goods and services that there's no objection to at all. So at that point, you might divide out your other classes of goods and services into what is known as a child application. Then that way the class 5 would stay in the parent application and would be placed in suspended status given the scenario I just mentioned. There could be other ways that you would handle that the parent application. But the other classes would then be approved for publication and would move to registration. On a docketing note, the new serial number is not assigned immediately when you file a request to divide. The new serial number is not assigned until the request to divide is reviewed and accepted, and then you will get your new filing receipt, a new notice of allowance, or whatever it may be that has the new serial number on it for the goods that are divided out at that point.
And just listening to all this stuff about divisional applications, you can just imagine that docketing divisional applications are a real challenge. However, my experience has been that the Trademark Office is doing a really good job in their documentation, explaining and indicating which goods and services go with which serial number, which class goes with which serial number, and which dates are applied to the parent, and then which dates are applied to the child. So it does take some extra effort as you're reading through these documents, as you're trying to get the new case entered into your docketing system, to make sure that you've got your goods and services and classes all set up correctly, and the dates for each of the 2 separate cases going forward. The other thing that I wanted to say was that, like a patent, if you're responding to a final office action on the final 6-month date, you must file the notice of appeal as well as your request for consideration so that the mark will not end up being abandoned if the examiner rejects your request for reconsideration. So that's the same as the patent process in that regard if you're waiting to that last 6-month deadline.
So the final rejection operates from a docketing standpoint the same as it does for someone who's used to docketing patents, in that if no action is taken in that 6-month period and the application is not allowed, then the application goes abandoned, right, Shelley? That's what you're saying?
Yes.
Okay.
If filing the request for reconsideration is not enough, you have to also file the notice of appeal by that 6-month deadline.
Okay, so you have to have both of them in there. Good point.
Yes.
All right, are you guys ready to go on to the next topic?
Yes, let's move on. Yes. So once an application has been approved by the examining attorney, it's going to pass to publication. You'll receive a notice assigning a publication date, and then you'll receive another notice later of confirming the publication of the mark in the official gazette. Once published, third parties have 30 days to oppose your mark, to oppose your application, or it'll be allowed. If you filed based on actual use, at this point the application will proceed to registration. But if you filed based on an intent to use, a notice of allowance will issue calling for you to prove up your use before the application can mature to registration. You're given a total of 36 months from the date of the notice of allowance to prove up your use, but you must file 6 months extensions along the way. There are 5 6-month extensions of time available, obviously. Even when you file your statement of use, though, with the specimens, if you have any concern at all about the specimens, you might consider filing a conditional extension of time along with it. This conditional extension gives you a little extra time to put the mark into use if the specimen is not accepted. if you don't file the conditional extension with your statement of use and your specimen is refused, you will have to provide a substitute specimen that was in use at least as early as the date you filed the original specimen. So that conditional extension might be necessary to give you a little more time to get a new specimen in place. But docketing can be really tricky for these filings, particularly, it kind of depends on the system you're in. I've been in FIP and I've been in PATSI, and one dockets them as one item, the extension and the statement of use as one item. The other one dockets the statement of use as one item and the extension request is another item. If it's one item, it gets really tricky, particularly if you file your statement of use early. You may file it 3 months before the deadline, but you don't want to file your conditional extension yet because there is a fee, and I'm sure you charge for your time. So to avoid the cost to the client, you might wait till closer to that actual 6-month deadline. At that point, if it hasn't been accepted, you might want to go ahead and file your conditional extension. But you need to be sure that you've kept that deadline, even though you filed a statement of use, that you've kept that deadline in your docket, so it's still showing as an active deadline. And then once the statement of use is accepted, you need to also be sure that there is a status check on the record until you get the certificate of registration. Again, special caution should be given to the docketing of these items if your docket system treats the statement of use and the extension as one docketed item.
And another thing along that line is some systems will launch all of the due dates, the 6-month due dates, the 12-month due dates, the 18-month due dates, all at one time, all the way up to the 36-month deadline. And other systems, it may just show the next deadline. Like I know, like in FIP, it gives you the 6-month deadline, and once you complete or close that docket date, it will launch the next deadline. So you don't see all of them up to the 36-month date on the docket at one time. And again, it's getting used to whatever system you're working with. However, one thing here is that final 36-month deadline is for the statement of use only. No further extension of time can be filed after the 30-month extension has been filed. And as Patty mentioned, once that statement of use is filed and accepted, then this ITU mark will progress to registration as well, and your status check should be out there waiting for that certificate of registration.
Well, in listening to your comments, both Patty and Shelley, it occurs to me that the way somebody handles docketing for trademarks is not just a function of the trademark office's procedural requirements, but it's also a function of the docketing systems that they're working in and how the docketing system handles certain things. And that then, for me, emphasizes the importance of having good procedures and documentation in your particular law firm or company so that whoever is working in your docketing system knows how these things are handled and knows whether you should take both dates off or if both dates are encompassed in a single deadline. So documentation is very, very important in making sure things are done correctly too. Would you both agree?
Oh, yes.
Absolutely. Absolutely. You have to understand your system, and documentation is vital in that.
Good. All right, Patty, back to you.
Yeah, but maintaining your registration. So you have to file a declaration of use, which is a Section 8, between the 5th and 6th year after registration. And you can file an affidavit of incontestability, which is a Section 15, anytime after the 5th year. Most often, we file them together. It's a Section 8 and 15, and it's filed sometime between the 5th and 6th years. However, there may be reasons why you're not filing the Section 15, and that discussion is outside the scope of our webinar today, but we can address them in the future. So while the deadline is 6 years, which is the date most people docket for filing the Section 8 and 15, filing is possible after 1 year, is possible 1 year prior. And so we usually docket the 9-year deadline as well as the final 10-year deadline. one of the reasons we do this is that there are companies, third-party companies that go in and do data mining, I guess is the right term for it, and they go into the trademark office and they download all the information and they send out letters to registrants advertising their service for handling the maintenance filing. But oftentimes their documentation doesn't really look like a solicitation. It looks more like an official document that needs to be acted on immediately. And oftentimes they have very confusing names like United States Trademark Agency or something of that nature, where people see it. If you're not a very sophisticated trademark owner, you might see that and think you need to act on that, or maybe that's the only notification you're going to get. So we like to contact the clients at the 5-year point and the 9-year point for the renewal. I'm sorry, I think I said that earlier, it's the 5th and 6th year. But anyway, so we like to contact them on the early end of that deadline so they know that we're here for them and we're gonna handle that filing for them if they want to maintain the registration. And it avoids a lot of the confusion. At that point, sometimes they say, well, I already got this, and they send us a copy. We're like, that's exactly what that is. There's no need for you to act on that. And sometimes the fees associated with those companies are exorbitant. And there's not all the other background. Those companies don't have all your clients' background. Additionally, there is a 6-month grace period available for filing the declaration of use, so be sure that's docketed if there's any reason why you're having trouble getting instructions from your client or getting an acceptable specimen, because once that grace period expires, failure to file Section 8 will result in the cancellation of the registration. Also, I wanted to point out that if it's a Madrid filing, if it's a U.S. registration that's an extension from a Madrid filing, that Section 8 is going to be replaced by a Section 71. So similarly, at the 10-year point, another Section 8, as well as a Section 9, which is the application for renewal, are due. Kind of the same thing I've already discussed. We like to contact the client on the early end, and a 6-month grace period is available for this as well. And then once the registration is renewed, further renewals are due every 10 years in perpetuity, as long as the client is using and wants to maintain the registration.
So just to kind of get this a little bit straight in my head, this took a while for me to understand these different sections. The Section 8 is actually the applicant indicating that they're still using the mark, and they have to supply proof of that. The Section 15 relates to incontestability, and it's basically saying that the mark has been in continuous use for a specific length of time and that there have been no third-party problems. Maybe that's something we can talk about it's a little deeper than this webinar is going. So when the 8 and 15 is filed, the applicant is saying we're still using the mark. So give us, accept this declaration and let us go to 10 years. When the renewal deadline comes around at 10 years, the Section 8 declaration of use is again filed along with specimens proving that you're still using it, along with the Section 9 or the renewal application. And as Patty said, this continues every 10 years until the mark is no longer wanted or used by the applicant. So it's just a matter of the applicant has to continuously confirm that they're still using the mark with that Section 8 filing, and as long as they're using it, that shouldn't be an issue at all.
So that requirement then just continues indefinitely, right? As long as they're using the mark. So if you have a mark like Coca-Cola or something that's been in use for many, many, many years, they keep having to do that every 10 years?
Yes.
Yes.
That is correct.
Well, thank you both for explaining Section 8, 9, and 15 to me. As a patent attorney, I've never really understood those. So that was really, really helpful. I appreciate that.
Sure.
Oops, I went one slide too far here. Okay. I want to remind everybody that you can submit questions if you have questions, and we have a couple in the queue, using the question button on the control bar on your screen. If you have specific questions about Black Hills IP services or processes, you can contact our Vice President of Sales, Jim Brophy, and I've put his contact information on this slide. let me go to the questions that we have submitted already and present these to Patty and Shelley for their input. The first question relates to CPI, and I don't know if we have the answer to this or not, but I'm going to throw it out there, maybe Shelley. In the CPI system, how do other people differentiate between a use mark and an ITU mark? Shelley, do you know from your CPI days?
I believe there's the field on the country application page, a little box on the, if I say I believe this, and now I can actually see it, on the country application page on the right-hand side, I think it says in use. So if it's in use, you check that box. At least the two latest systems that I've been in, that's where I remember seeing it.
You know, and let me just at this point mention another resource to the listeners. We have a group in LinkedIn. Docketing Excellence is the name of the group, and there's probably close to 500 docketing professionals and IP professionals in that group. And my hope is that that group can also be a forum for questions like this. If you have a question about a particular system and you need to find somebody else who uses it. So I think this would be a great example to put out on that Docketing Excellence LinkedIn group as well, because there's probably some other CPI users that are members of that too, who will have some thoughts and input. Shelley, do you agree on that?
Yeah, I think so. You could probably, whoever answered it, instead of just saying it from my memory and seeing the picture in my head, I could probably also put a little screenshot in there of where it is in the system that I'm using, so that it's easier for someone who asks the question to find it in their system.
Mm-hmm. Yep. So that's a resource that's out there, and if you're not a member of it, we'd love you to join. The easiest way to do it is to go to our website and go to the Docketing Excellence series materials, and there's a spot where you can join the LinkedIn group, or you can also do it through LinkedIn itself. Next question. How many months do you docket for a status check after the response is filed? Is there a right or wrong answer to that, Patty and Shelley?
This is Patty. I don't know if there's a right or wrong answer. We typically docket 3 months, but I think if I'm not mistaken, that you have a duty to not let more than 6 months go by.
I agree with that. I think the duty is 6 months. Most of the customers that we work with at Black Hills IP have asked us to do 3 months. So I think that's quite common.
Sounds like 3 months is maybe the best practice, or at least the common practice that's out there then for docketing trademark status checks, correct?
Yes, I would agree to that.
Okay. Next one. Is there any after final process for trademark applications? So Patty, I want to present this one to you. And in my mind, when I hear after final process, I think about patent applications. Once you get to the point that you have a final rejection, there's certain things that you can try to do with the examiner at that point. Is there anything similar for a trademark application once it's on final rejection?
Well, you can appeal the decision, but oftentimes you're appealing again to the examiner, and then it is reviewed by the director. I don't know that we've seen a lot of success in filing appeal, but it is an option.
Okay, so it sounds like for the people that are more coming from a patent docketing background, there's some programs that the USPTO has implemented recently to encourage the examiners to work a little bit more with the applicant on a patent application after final. In fact, there's one called the After Final 2.0 process. But I don't think there's quite as much.
I don't think there's anything
what
like
you're
that.
saying, Patty.
I'm not aware of anything right now, but I mean that's not to say there isn't. But I'm not aware of anything like that with regard to trademarks.
Okay, good. Okay, next question. Let's see. If a request for reconsideration is filed without a notice of appeal, on the 6-month deadline and the application did not get allowed, the application will go abandoned, correct? That's right, isn't it, Patty?
Correct. Yes, that is correct.
Okay.
You have to file the notice of appeal.
Perfect. So that's critical to make sure that is also docketed.
Correct.
All right. Next question. This gets into the sections 8, 9, and 15. At the 5-year mark, if you choose not to file section 15, do you still file section 8/9 or only section 8 at the 5-year mark?
Well, at the 5-year point, you wouldn't file section 9. Section 9 would be for the renewal, which is 10 years. You would still file your section 8 because the section 8 is going to be what keeps your registration alive. The section 15 is just an affidavit of incontestability, and it's not really accepted. It's even when you file it, they don't call it accepting it; they call it acknowledging it, that you're filing it and you're saying that you've used the mark and it has not been contested by any third parties. But the section 8 is required. You have to file that section 8 before the end of that 6-year period, or the registration will fall abandoned or be canceled, administratively canceled. And then you need to file another one at the 10-year mark.
Okay, good.
Failure to file the section 15 will not have any effect on the life of the registration.
All right, this I think gets into divisionals. Would you recommend opening the divide new case when the request is filed, or do you wait for the document from the PTO with the child application serial number before opening the child case?
Shelley, you want to do it?
That's a good question. Well, what I can say is I think some of it depends on how your docketing is done. In a system like Foundation IP, where documents are housed within the matter, within Foundation IP, you might want to open it early so that your filed documents can be in that matter, even though it may still have an unfiled status, or you may not have a serial number for it. But in situations in software programs where you aren't putting documents in, I guess it would be an organizational decision as to when you want to open that up. I don't see a reason to open it before you have the information because you don't know what the serial number is. You don't know what the due dates are going to be. You don't even know for sure, and Patty, I'm kind of guessing on this, you don't even know for sure that your request to divide is going to be accepted.
Well, you don't really, I mean, it is formally accepted, but I don't know that I've ever seen one rejected. The reason that we open them here is because all of the application dates and all of those things are going to follow to the child. So if you have, for example, if you divide at the statement of use level, you're going to prove up use on a few, and you're going to divide out the others. Those dates are going to travel to the child. And so you're going to still have the same extension dates and all those kind of things. And what I have done is I will put like a TBA under the serial number, but have the application number there and all of those things there, and the goods that are going to be in that child application to help our docketers know when they look at it, like they know something is going on, and if they don't catch it right away, they know that this that we did file something off the other one because they're the same mark and the same filing date, and it kind of gives them a starting point. And you can put all the documents in there. You know, the same documents you filed, my filing receipts and things like that, I go ahead and put that in the child as well.
And then your docketing team is not kind of caught flat-footed when the request to divide is granted and they've got all this new information in front of them. Okay.
Correct.
Good tips. Okay, here's a little bit different question, and I'm curious to see if either of you have any tips for this person. This person says we do not use docketing software. Any tips for manually docketing trademarks?
Whoa, I don't. I remember back to the day before I started using Patsy 20 years ago that we had card files.
I do too.
We had card files that were by serial numbers and another set of cards that were by client. And boy, that was a challenge.
The biggest thing is to make sure that whatever you're using to track your dates, you are being consistent. Every single document that comes in is looked at, and the dates are added to whatever. Is it a spreadsheet? Is it card files? Is it whatever? It gets a little difficult, I think, when it comes to crossing dates off the docket. But if you've got them there, you can at least check on them on the due date. I don't know that I've got any other tips.
I don't think I do either. I'm sorry.
That's a hard one. But, I mean, oftentimes people that have electronic docketing systems have a secondary or a backup docket that they keep manually. And just thinking about it from the standpoint of how do people approach a secondary docket, that could be something as simple as a day planner where the dates are manually tracked on the right day on that paper day planner. It could be trying to track them through an Outlook calendar, putting them on the Outlook calendar. There's a spreadsheet. Shelley, you mentioned a spreadsheet, trying to track on a spreadsheet. But like you guys said, the most important thing is being consistent, making sure everything's getting on there. But there are a lot of ways to do it. Okay, so the last few questions have to do more with the webinar itself. Can we get a copy of the presentation? The slides will be available on our website. Give us a day or two to get those posted. There will also be an audio recording of the program posted as well. So this and any of our previous docketing webinars all get posted on the Black Hills IP website, so you'll be able to go back and view them there and get the slides if you want to have the slides as well. I think that's it for the questions. We've had some great questions on today's program, and I'm really looking forward to this trademark docketing webinar series that we're starting off here. The next trademark docketing webinar will be on February 7th. At 1 p.m. Central. You can go to our website to register for that right now. That's already available with the registration information. The topic is common U.S. trademark docketing mistakes and how to avoid them. Patty and Shelley, I want to thank both of you for sharing all of your experience today. The combined experience between the two of you is just amazing to me. I think you guys are experts, and I've learned from today's program. So thank you so much for doing a great job and sharing your wisdom with everybody else. Thank you very much, and I want to thank our audience for signing on today, and hopefully you'll join us for more discussions on trademark docketing. So thank you very much. That's it for today.